Hello, I am Sherry Tucker with Tucker Legal Services, a law firm located in St. Louis, Missouri. I focus on estate planning and elder law. Today, I want to talk to you about something that has started occurring more since the pandemic, and that is the do-it-yourself estate plan. I want to talk to you specifically about what might happen on a do-it-yourself, this DIY project. The DIY exists in many different areas, such as landscaping, bathroom remodeling, and even pouring a patio. We've gotten into a habit of clicking on the website and looking at how to do something ourselves. Consumers browse through the websites and links, watching instructional videos and reading the how-to manuals. People read and try to find answers about complex questions. If a mistake happens, or that DIY doesn't come out exactly the way it should have, the fallback plan is either try to fix it yourself again, or to hire a professional. While a physical project is fixable, mistakes in a last will and testament are not correctable. Whether you are considering writing your own will or using an online do-it-yourself document creator, many reasons exist that demonstrate why this one project is one you should not undertake without the help of an estate planning attorney. If a mistake happens and it's not correctable because a mistake is only found out at death when the will is filed. So exactly what is a do-it-yourself estate plan? Well, because of the current pandemic, many Americans became aware of the importance of creating or updating estate planning documents. Many people mistakenly believe that an estate plan is merely wishes written on a piece of paper. A DIY estate plan is when a person handwrites a will for him or herself. Perhaps the person downloads a fill-in-the-blank document from the internet or answers some preset questions on an online document generator. If it's on a website, what is the problem with the DIY estate plan? If it's bought online and touts developed by attorneys, isn't it good enough for you to do it yourself? Well, there are some common mistakes. When it comes to a DIY estate plan, these common mistakes exist. You may fix an oops for a home project, but an estate plan oops mandates professional help, which is costly. Sometimes that big mistake, well, it's just too late to fix. When a person dies, the document that's in place, well, that's it. At death, you or even your family can't fix the mistake. So let's talk about these mistakes that might happen if you do an estate plan yourself. One claim that when you download a document or you buy the $99 document from one of the business suppliers, the form says meets state law. Many website forms may claim to conform to state law, but most often this is not the case. Laws differ from state to state. States vary in what constitutes a valid last will and testament. And the online form may not meet those state legal requirements for a valid last will and testament. The generic form may not adequately address the legal issues about property that you may have in other states. To be valid, a last will and testament must meet state laws. Issues occur too when you have a form, but it's not updated. It's not updated to meet state laws that have changed, or even federal laws that have changed. Often, the DIYer does not update the plan or understand a need to update the plan. New tax laws can affect estate planning. Case law and statutory revisions affect estate planning. Overall, that DIY estate plan is pricier. It's not a touchdown. It's not a catch of a Hail Mary pass. It is a missed throw in the end zone. DIY estate plan increases information problems. The document could contain inaccurate, incomplete, or even contradictory information to what you are wanting to accomplish. Creating a will using an online questionnaire increases the possibility of selecting wrong choices. Worse, the generic form may cause a person to leave out important information. Potential problems happen when a do-it-yourself service allows users to insert additional information that's not addressed by the preset questionnaire. The added information by the DIY usually contradicts other parts of an automated will. The ease of just logging into your account to make changes raises questions. Do you know, for example, how the Secure Act affected your retirement benefits? What is portability? And do you need to adjust your estate plan? Did a spouse become incapacitated? What changes should you consider? These information problems may prevent a person's will from accomplishing desired goals. Worse yet, it may not mean what you think it means. In the end, it is better to work with an estate planning attorney to make sure your plan truly is peace of mind for you and your family. One thing I'd like for you to think about too is how words matter. Words in estate planning have very specific definitions. Perhaps the DIY includes a living trust where one just fills in basic information. The result is a low-price living trust with legal terms that a person, you, may not understand. What is the difference, for example, between a beneficiary and a designated beneficiary? Do you include unitrust language or not? What is a general power of appointment, and do you need it? What is a limited testamentary power of appointment? A revocable living trust should not be a generic document. It is a living plan with specific language that helps put the right financial goals in place for you and your family. Regular meetings with an estate planning attorney ensure that your plan accomplishes your goals instead of causing major headaches for your family, who is already in a grieving process at the end of a grantor's life. So when we're thinking about estate planning, it is more than this piece of paper. It's not a generic form. It should not be a generic form. People who price shop, they're looking for the cheap. They're looking for something that's very easy in their mind to make their wishes known. And there is cheap out there. There is the do it yourself. There are the forms that you can fill out. There are even attorneys who are less experienced, and they start out and they, maybe give you a very low price. In the end, what you really, really need for an estate plan is peace of mind, knowing that what is in place is really, truly what your family needs. On the estate planning part of it, one thing that an estate planning attorney should be doing is making sure that as you go through life changes, your estate plan reflects those life changes for you and your family. If you have this DIY, oftentimes it's like disregarded. It's just a piece of paper to you. It's stuck in a drawer or put in a safety deposit box. And then when a life change happens, you just kind of forget about it. And that document no longer really adequately protects the family for those life changes. What are some life-changing circumstances that fill in the blank form that you print out may not even account for? What if both you and your spouse die simultaneously? Do you really understand all the choices? If your child dies before you do, who receives your assets? Did you remember to change anything? What if there are no grandchildren? What if your child has large debt? What if your child becomes a drug addict or a spendthrift or a gambling addict? What then? Do you want inheritance to pay off debt? What happens if property is left to a child but sold before death? Does that mean that they receive nothing? Even worse, what happens if down the road, the person who has the will and has the trust, what if they develop dementia or Alzheimer's? Does that generic last will, that DIY that you did, does that really, really protect you and your family in the event of incapacity? Unfortunately, many people do not have good DIY plans for life changes. So, what about estate planning attorneys and going to estate planning attorneys? Your estate planning attorney should not be a one and done attorney. Now, there are clients, they feel like, oh, I've got my form, I've got my will, I've got my powers of attorney, I've got a trust, I've named guardians for my kids. I don't need to talk to my estate planning attorney over time. A good estate planning attorney is there for you, not a one and done, not a here you go and out the door. You need an estate planning attorney who believes in a legacy protection plan, who wants to stay with you, who wants to make sure that your document truly reflects your family needs along the life changes. When you have a document and you forget about it and you don't update it and you don't stay in touch with your attorney, it can lead to a false sense of security. A DIY estate plan does not achieve what you think it does. It may not be valid. An invalid plan means your property and money will go to heirs specified by state law. That may not be your choice. You may have substantial issues in there that you don't know about if you didn't follow new tax law requirements. Not understanding current tax laws and changes can affect your family. A trust means nothing if you don't fund it. An unfunded trust is an ineffective estate plan. It means that your property will still go through probate. So what I'd like for you to remember is that even when a document says lawyer developed, and hiring an estate planning lawyer, it is not comparable. You and your family deserve to sit down with an estate planning attorney for a life plan design that protects your legacy. We all have stories to tell, and we have stories we want to leave behind to the next generation. And getting an estate plan in place that meets those needs gives you peace of mind and allows you to leave the legacy that you want to leave. So just remember, when you're working with this estate plan, you want an attorney who is going to be there with you, preferably the same attorney. Out there are those that say you can hire an attorney to help you with your DIY estate plan that you just filled out in a questionnaire. Well, sure. Is it always going to be the same attorney? How do you know? Who's an expert team that will help answer your questions? Paralegal? Who's giving you the legal advice? Is the person licensed to practice law? Today, attorneys strive to hone skills in specific legal areas to better serve the client. So when it comes to your estate plan, you and your family deserve more than a bunch of words on a piece of paper. You deserve that peace of mind where a person comes in and explains the terminology to you, asks you questions, and really helps you set out the right estate plan that you and your family need. DIY. It may be great for some of those projects online. And then if you mess up, well, you usually have to hire a professional to fix what you couldn't quite get done on your own. But if you do it with your estate plan, it can be too late. It's not fixable. So think about how you want peace of mind in your estate planning process. I'm Sherry Tucker with Tucker Legal Services, and I'm an estate planning elder law attorney. My law firm is focused in St. Louis, Missouri. And of course, as you listen to this, think about the DIY situation. And remember, hiring an attorney is a very important decision that you make. And it should not be based solely on any advertisement or social media.